Let me go ahead and introduce our panelists. To my left, I have Angela Corey, who is the State Attorney for the 4th Judicial Circuit of Florida. Ms. Corey received a Bachelor of Science degree in Marketing from Florida State University and her JD from University of Florida. She is a 33-year veteran prosecutor, and what's that? 34 yesterday, and was elected in 2008 to this position, where she's tried hundreds of cases, including 50 homicides. She's continued to try homicide cases since she's been elected. She's also taught classes for the Police Academy at Florida State College, and currently serves on the Board of Trustees at Episcopal High School of Jacksonville, the Northeast Florida Builders Care Association of Jacksonville, as well as the Military Public Safety and Security Advisory Board for FSCJ. So, welcome, Ms. Corey. To her left, we are also honored to have John Guy, an Assistant State Attorney for the 4th Judicial Circuit here in Jacksonville. He's been a prosecutor since graduating from the University of Florida College of Law in 1992, and is currently a Managing Director assigned to the Homicide Major Crimes Unit, which oversees the prosecution of all homicides and major gun cases in Jacksonville. Mr. Guy has handled homicide cases since 1985 and has been the lead prosecutor in more than 100 jury trials, including 49 murder trials and 7 capital trials, and including some high-profile trials such as the Zimmerman and the Dunn cases, which we're all very familiar with. Mr. Guy was a faculty member of the National District Attorneys Association from 2002 to 2010, has also lectured for the American Prosecutors Research Institute, Florida Prosecuting Attorneys Association, and he currently teaches trial practice as an adjunct here at Florida Coastal. And we are very honored to have Mr. Guy. All right, to my right I have Mr. Jim Hernandez, who graduated from the University of Alabama Law School with honors in 1986. He was both an active duty and reserve in the Marine Corps, active duty and reserves between 1986 to 2000. He was a Marine JAG serving as a Special Assistant U.S. Attorney, military prosecutor, and military defense lawyer. Happy Veterans Day, by the way, Mr. Hernandez.
Happy Marine Corps Monday first.
And that too. After his time as a JAG, he was the Assistant Public Defender for the 4th Judicial Circuit. He's now a solo practitioner, has argued before the U.S. 11th Circuit Court of Appeals and the U.S. Court of Appeals for the Armed Forces. He's handled 18 death penalty cases. 15 of his clients have received an acquittal or found guilty of an LIO, received a jury, he's got a lot of qualifiers on here, received a jury recommendation of life, or entered into a plea deal, or, no, that's it. Only 3 of his clients have received a sentence of death. So that's a good hard, fast number. We're honored to have Mr. Hernandez. Next to him is Kelly Bynum, one of our own grads from Florida Coastal in 2006, now a solo practitioner and owner and president of the law offices of Kelly J. Bynum. She opened her firm in June of 2009 and practices primarily criminal defense. She was a prosecutor with the State Attorney's Office prior to that, and she's been handling death penalty cases for almost 3 years and is qualified as both co- and lead counsel. Kelly, welcome back. And last but not least, we have Alan Chipperfield, who's graduated from Washington and Lee School of Law in 1976, worked in civil practice for 6 years, and has spent the rest of his time at the Public Defender's Office in Jacksonville and Gainesville, where he's had a lot of criminal defense work for almost 33 and a half years, and has been involved in capital cases since the 1980s. With a wealth of experience, we are honored to have Mr. Chipperfield. All right, so we've got lots of panelists and lots of good areas to talk about. We're hoping to hit just a few little topics such as deterrence, wrongful convictions, the lethal injection, means of execution, potential discrimination, just non-controversial things like that. But let's start off with something that's probably on everybody's mind right now, and that is the question of the unanimous jury verdict. Currently, the United States Supreme Court has got a Florida case, the Hearst case that they're looking at, and And I was wondering if the panelists, and maybe I'll start with Ms. Corey if you would, could address that case a little bit and talk about this unanimous jury verdict issue and what it would do, for instance, in Florida if the Supreme Court were to rule that it needed to be a unanimous jury verdict. Ms. Corey?
Well, I'm just going to make a couple of brief comments. Obviously, our job as prosecutors is to follow the law. So whatever laws our Supreme Court or our legislature come down with, we will follow those. And we implement the policies and procedures for the death penalty as they are stated in our laws now. If that case gets decided where unanimous jury verdicts are required, we would be seeking the death penalty knowing that we would need a unanimous jury verdict. But John, did you want to add to that?
Well, I can tell you, I think for the public and juries, it would be a learning curve somewhat. I mean, right now, we just require a simple majority, 7-5 gets you a death penalty. 6 and 6 goes to a life sentence. But I think it would be a learning curve. I think there may be a tendency, I've never been in a jury deliberation room, but I think there may be a tendency as they're going around the room with their vote for someone who believes the state has met its burden in recommending or having the recommendation of death, but doesn't want to do it personally, and say 8 people have already said yes, they can say no, because they know it doesn't matter, because the person's already going to get death. So I think you'll see, we don't have a lot of 12-0 verdicts in Florida, but I think that may be in part because we don't need it. I think if it's required, I think we will see 12-0 verdicts.
All right, and by the way, are you guys able to hear in the back? Are those mics good enough? All right, excellent. What about on this side? Do you guys anticipate if the Supreme Court rules for unanimous jury verdict, this could have an impact on death penalty litigation in Florida? Anybody want to take that?
Basically, what I want to see as a defense counsel, I want to see the jury instruction change that says that the jury's recommendation is just an advisory recommendation. I want it to be like Ring, following the Ring case law, where the jury knows that they are morally responsible for whatever they say. That's going to happen. That's what I'd like to see. As it stands right now, our jurors get a bye, they get a pass, because you go into that jury room and say, well, the judge is going to take care of it. The judge is going to be the ultimate person that does the sentencing. And mine's only a recommendation. Well, what they don't know is that the judges are going to follow the recommendation. So that's what I want to see. And I'm leaving a lot of purse left for some other 2 panel members can dig in.
All right, so what about the Hearst case and the way the jury decided that verdict would make you think, if you do think this way, that there might be a constitutional issue involved? Either one of you?
Well, I'm going to stay seated because I've come closer to the mic if I do that. I think really there are 2 issues of jury unanimity. One is that in Florida is the only state in the whole country that both doesn't require the jury to be unanimous on an aggravating circumstance in order to justify the death penalty, to put the person into the category of those who can receive death, and doesn't require a unanimous jury to recommend death. In fact, Florida has executed 2 people who had 12-0 votes for life, because a judge in Florida and only 2 other states in the country can override the jury recommendation. It's happened 3 times in Alabama, but none of those guys have been executed, but Florida's executed 2 people. So there are really 2 different issues of unanimity, and I think they're both involved in Hearst. And how Hearst will be decided, I don't think anybody really knows.
And if I could add to, can you guys hear me? If I could add to that, obviously, as you know, when I was introduced, I've only been doing death penalty work for right at 3 years. And one of the first things that kind of appalled me is that we are just a bare majority state. So as Mr. Guy stated, 7-5, that vote can give somebody death. Whereas in the guilt phase of the trial, it does have to be unanimous. It has to be 12-0. So I've always just found it appalling, really, that it has to be unanimous to find the person guilty, but then it's just a bare majority to actually sentence that person to death. And I say sentence them to death, and I know it's the judge that actually hands down the sentence, but as Mr. Hernandez said, the recommendation by the jury is taken very, very seriously by the judge. The judge can override that, but it's rare. And so the main issue in Hearst, I do think that Florida needs to be a unanimous vote for death, like it needs to be, and like it's always been in the guilt phase.
Can I ask a question maybe on this side? What is Florida's justification, as you may understand it, as to why we would not want to do it unanimously, or why, we'd go 12-0 on the findings phase, but then on the sentencing go less than that?
Well, I mean, I don't know the rationale. The law is that it is an advisory recommendation given great weight by the court. And I disagree with Jim that we should make a jury morally responsible, because where would that end? When we're looking at consecutive life sentences on somebody, should we have a jury have to decide that sentence and be morally responsible for putting someone who's committed 12 different armed robberies and needs to be put in prison for the rest of their lives? Where would you ever end with trying to hold a jury accountable for the sentencing aspects of a crime? The judges know these laws, they understand the aggravators. I believe, as Mr. Guy said, that if we start educating juries as to why we need unanimous verdicts, we will see unanimous verdicts. Right now, we just don't have to push the issue that hard, but we do very carefully take cases to trial where the aggravation outweighs the mitigation. And so we believe that the jurors are basing a recommendation on what they hear in the courtroom. The judge, who hears even more, see, that's what hasn't been mentioned yet, there's an additional hearing between the penalty phase where the jury makes a recommendation. It's called the Spencer hearing. And the defense can come in and present anything else they want to the court to try to mitigate the sentence. And only then, after that third hearing, so you've had the guilt phase, the penalty phase, the Spencer hearing, and then the ultimate sentence handed down by the judge, where he has to very carefully craft an order stating why he believes the death penalty is appropriate.
Can I add something to that? Just to breathe a little life into this notion that it is a recommendation, but the judge makes the ultimate sense. Mr. Chipfield just told us about 2 cases where the judge overrode the jury's recommendation. And I had a case just a few years back down in Clay County, and the death recommendation was 8-4 for death. And on the spot, without a Spencer hearing, perhaps not by the rules, the judge sentenced him to life right there on the spot after an 8-4 recommendation for death. So it is a recommendation, but it has to be given great weight by the court. Sometimes judges follow it, sometimes they don't.
Actually, just maybe addressing that real quick, isn't it actually more fair this way to let the judge be the final, with the Spencer hearing? Does the defense want it to be that what the jury says goes?
And it's probably my background in initially starting to practice law in the military. In the military, every court-martial that goes before a jury, the jury decides the sentence. They decide the sentence by voting for the lowest sentence, and once they have a simple majority, that's the sentence. They go from lowest to highest. So maybe it's my background in that knowing that a jury can be the consciousness of the community. Consciousness of the community. I think I heard that in Ring. And that's what I'd like our juries to have. They'd like to have the responsibility, when they go back there, to not shift the burden. Now, you got to remember that in order for a person to get on a death penalty trial, they have to be death penalty qualified. So all the folks who do not believe in the death penalty, or who cannot consider death as a possible penalty, we're off your jury. We're not even close. What you have is the people who basically could consider it, and people who are strong advocates for the death penalty. But that's...
Well, one of the problems that with the Florida statute is, well, number one, in answer to your question about the judge, I'd be much more comfortable with the judge making the decision if he wasn't an elected official. But, and I'm not just being cynical about that, there are studies that show that at the time of election, there are more jury overrides than at any other time. Judges are elected, they know the political pressure, and they're careful about that. And that's not all judges, but it happens. Number two, if you're going to let the judge decide, what Florida does that, and I think does that in violation of the Constitution, because Ring decided that if there is a fact to be proven, that elevates the maximum penalty after conviction of offense, that fact has to be found by a jury. Well, the maximum penalty for first-degree murder is life if there is no proof of an aggravating circumstance. So the proof of the aggravator is what makes you death eligible. A jury doesn't make that finding in Florida. They're told that they have to find an aggravator, but there is no verdict or no specific finding of a jury. In fact, at the Spencer hearing, the judge can find an aggravating circumstance, he can disagree with what the jury did, and find an aggravating circumstance on his own that justifies the death penalty, which might completely ignore what the jury has said. So in answer to your question, I'm more comfortable with juries making the ultimate decision than I am with the judge.
I see.
I've got to rebut that.
Yeah.
Juries do find unanimously a lot of the aggravating factors. Premeditation, but not heightened premeditation. They come back in. Felony murder by their verdict is a unanimous finding of crime that qualifies that person for the death penalty. Certain crimes, if the child is under a certain age, and that's a qualifier, and the jury has found the person guilty of a capital sexual battery as well as the murder of the child under the age of 12. All of that's unanimous. In fact, one of the things we do as the state, we stand up in the penalty phase and rely on all the facts and circumstances proven in the guilt phase because so much of it is underlying. There are only a few, murder of a law enforcement officer, aggravating factor that's automatically proven by the jury when they render their verdict, or you wouldn't be in a penalty phase. So I do disagree with Mr. Chipperfield. There's plenty of unanimity among the jury for most of the aggravating circumstances.
Great. All right, so let me shift topics just a little bit, and actually go back to maybe on this side. So let's say we want juries to do this. Some people are concerned that because of the discretion that is authorized in death penalty cases, there's potential for discrimination, and specifically for racial discrimination, I guess is a big concern. Maybe on this side, is there any data that you know of to support that, either anecdotally from what you've seen or statistically, and how does that play into the desire to have juries making these verdicts?
Well, I'll answer there. I mean, in Georgia, just last week, the Supreme Court heard arguments about discrimination in jury selection. Prosecutors are not supposed to exercise, prosecutors and defense attorneys get cause challenges when some juror admits that he can't be fair. But there are also peremptory challenges, and those are challenges that can be exercised for any reason other than a discriminatory reason. The case that was heard by the Supreme Court from Georgia involved prosecutors. The argument is that they intentionally used peremptory challenges against blacks. And they had some pretty good evidence that that was going on. And even though they did it, they had that evidence, the prosecutors had said, oh no, I'm challenging this person for some other reason, which would be a legitimate peremptory challenge. But there's pretty good evidence that they were being discriminated against because of race. So that's one place where race enters into the application of the death penalty, and that's pretty arbitrary. It's the same kind of arbitrariness that caused the death penalty to be held unconstitutional back in the early 70s.
All right, anybody else on this side want to address that?
I feel like, just from my personal experience, this isn't a statistic, but just in the jury selections I've sat in for the death penalty, I feel like, and they've all actually been with Mr. Hernandez, we give the jury a scale from 0 to 5. 0 is you're 100% against the death penalty, 5 is obviously you're 100% for it. And then you have to, even the 5s, you go back and ask, well, could you consider mitigation and vote for death, or I'm sorry, vote for life? And to the 0s, could you consider aggravation and vote for death? And in my personal experience, a lot of African Americans are either 0s and they can't consider aggravation to vote for death, so they are automatically off the jury if we cannot rehabilitate them. And I've also noticed a lot are 3s, and so because they're right in the middle and could go either way, the state is going to do, what they can to exclude them from the jury, not because of the race, but because they're 3s. But that correlation is something that I've personally observed.
Okay. What do you guys think on the race issue?
Yeah. Just so y'all know, when a case comes before us and we need to decide whether or not death is an appropriate penalty, it's a legal decision, not one that we just think, oh, this case sounds like it, or this is a minority, or this is a white person. That's not a fact. Okay, there are 16 aggravating circumstances in the Florida statutes. That's what we are governed by. Do we have sufficient number and quality of aggravating circumstances to seek the death penalty? Doesn't matter what race they are, the defendant or the victim. It's just whether or not we kind of check those boxes. So the suggestion that we seek the death penalty more on minorities is just, frankly, it's insulting. That's just not what we are to do professionally and ethically, and that's not what we do. It either the person qualifies for the death penalty or they don't, regardless of race, age, creed, color, any of that. Like I said, for either the defendant or the victim. It's a legal decision.
The only statistic that stands out is we seek the death penalty on men far more than we do on women. That's the only actual statistic. And the reason behind that is more men commit those kind of vicious, heinous, atrocious crimes that qualify for the death penalty. So there is no gender discrimination, there is no race discrimination, and quite frankly, a lot of our victims that are murdered in a heinous fashion are black. So we value that life and seek the death penalty when the rules and the statutes say we should seek the death penalty for the loss of that valuable life.
Can I just give a couple numbers? I looked this up just because I knew I was coming. Just so you know, currently on Florida's death row, there are 224 white males on death row. There are 150 black males, and there are 12 males that they described as other. But those are the numbers, 224, 150, and 12.
And how many women?
I think, well, there's like 4 or 5.
Okay.
Can I just respond?
Yeah,
real
please.
quickly? The Supreme Court of the United States decided years ago that the statistics show racial discrimination in the administration of the death penalty, but they can't do anything about it. And the discrimination is not in charging African Americans. The discrimination is in the race of the victim. And when the race of the victim is white, there is a much better chance that the person who killed him will get the death penalty. And the Supreme Court recognized that those statistics are way out of line, but they just said we can't do anything about that.
And
That's a fact.
Ms. Corey, is that a valid statistic in this
Not in
circuit?
this circuit. In
No.
this circuit, our victims are our victims.
And I'm not making a claim that the other side of the table is doing this.
I know, but I want to make it clear to you that our victims are not a gender or a race or anything to us other than our victims. It's the number of gunshots. There's one color that matters. It's the red blood that bleeds out of their bodies when their clients brutally stab them 120 times or shoot them 10 or 12 times. And they've already committed a litany of horrendous crimes before we seek the death penalty on them. That's what matters to us as prosecutors. Whether our victim is a child or an elderly person who couldn't defend themselves. Those are the decisions we're making. Thank you.
So let me ask this question then, because actually what your last statement really talked about the brutality of the types of crimes that get capital treatment, and that might prompt some people to think, well, should we be humane in the executions, which will then lead us to, is there a humane way to execute people? Is lethal injection humane? That seems to be a big issue coming up. Does anybody on the side want to address your thoughts on that? The Marine, do you want to tell us about humane ways for killing people?
I got to admit, I'm very conflicted in this, and I have discussions, and it's a shame he's not here because he's a really good friend of mine, just like the other two folks across the aisle are. And before we get any further, there's no racial discrimination as far as who gets charged in the death penalty here in the Federal Judicial Circuit. Because if there was, we'd be all over it, okay? But going back, and we're not, as far as the private defense bar. But going back to any humane way to kill a person, all I've got to go back to is the upbringing in the Catholic Church, and I have had this discussion many times with Mr. Deli Rondo. And the Catholic Church gives you basically a pass to defend yourself in time of war and to defend this country. So I distinguish that greatly from the state or the people deciding whether someone should be killed. And to answer your question, no, there's no humane way to kill a person. It can be done. There's no humane way to kill a person.
So, do either of the two panelists on this side want to address? I know the lethal injection has been kind of up there as an issue, and that maybe it's not, in fact, humane, that it's cruel or unusual. Any thoughts on that?
Well, I think the issue has been that what most states use a three drug system where you have a pain reliever or a sedative that is supposed to work to stop pain. And then you have a paralytic that paralyzes and stops the breathing, and then you have poison that goes to the heart. And the problem has been, the arguments have been made that this midazolam that is in very common use, because now they can't get pentobarbital from Europe, isn't effective. And it doesn't stop the pain, but we cannot know that because of the paralytic agent. Because if you feel pain, you express it. But because of the paralytic, you can't express it. So we don't really know for sure in every case whether we're causing pain or not. And that's been the issue. And it's been consistently rejected. But that's been the issue.
Okay. What about on this side?
I can tell you that the first drug that Mr. Chipperfield mentioned is designed to render the person unconscious within 30 seconds. And that doesn't always work, but that's the design. But I don't think you kind of throw out the death penalty because we haven't found a more humane way to go about executing it, no pun intended. It's the current state of the law. You know, some states it's firing squad. Some states it's electrocution. Hanging was done for a long time. Now they have an election between the electric chair or lethal injection. So it is the law. If we can perfect it to make it less humane, that's great. But we're not going to throw out the death penalty.
You mean more humane, right? That Freudian slip there.
I don't want to give the softball answer, but this is the softball answer. Whatever means it is it not better than what the victim died from? Is that not the case?
Could you also, in Florida, are we having any issues with access to the drugs? I know in some of the other states, they apparently didn't even know which drugs they were using. I mean, do we have any issues that you know of in Florida on that?
I don't know of any. The only execution that I witnessed was one of the last in the electric chair. So, and that was Leo Alexander Jones, and that was years and years ago. So I've never witnessed the injection process and don't know that much about it. Can I throw something out for thought when you're talking about, is it inhumane to kill someone who has committed a set of facts in our society that we say is so egregious you forfeit your life? Anybody in here a believer in the Second Amendment and the right to use deadly force if you need to? Why do we have laws that allow you, if you catch someone in the act of doing one of these heinous crimes, you can take their life instantly and without any legal ramifications? But if we don't catch them in the act, but we catch them immediately thereafter and the proof is just as overwhelming, we want to say it's inhumane to take their life. Well, I don't understand the hypocrisy that you believe it's okay to have justifiable homicide, but the state itself, after tons and tons of due process, giving them the best lawyers they can have, all the motion hearings they need. We're a full discovery state, if you didn't already know that. We give the defense everything. I think there's two things still accepted under the rules. Confidential informants, if they're not involved in the transaction, and the law enforcement officer's notes, unless he has to refer to the notes. I mean, we give the defense everything. They know everything about the case, unlike in the federal system where they don't engage in this kind of discovery. So they're getting all of this due process, and then we're making a legal decision based on a ton of laws and a ton of factors to take their life. How is that inhumane?
Can I? You guys are law students, and you need, when an analogy is presented to you, you need to just not blindly accept it. You need to think about it. What was just presented to you was that one of the justifications for capital punishment is self-defense. The law of self-defense allows you to use deadly force to prevent harm. You can only use deadly force when it is imminent that deadly force is going to be used against you, or you're going to suffer great bodily harm or death. That's not the death penalty. The death penalty, a death has already occurred, and there's no imminent danger from the defendant. He's in jail, and you can put him in prison for the rest of his life with no parole. So a self-defense situation where you're acting out in the public and the death penalty are not analogous. I hope you all saw that right away.
It's, what I was referring to is you're making it a moral issue about taking a life, but nobody has a moral issue about justifiable use of deadly force. I'm not saying one justifies the other. I'm saying there's a set of facts that our law allows us to take human life. So if you don't want to make it a moral issue, I won't bring up analogies like that, but you guys on that side make it a moral issue.
So if it is a moral issue, and you mentioned the Catholic Church a second ago, I know, Pope Francis and others have spoken about the need for the death penalty, and I think Mr. Chipperfield's comments just now sort of alluded to this idea that maybe we don't need the death penalty if we can put people in jail for life and remove them from threatening society. And I don't know, maybe we can start on this side if you want to address that. I mean, what is the modern need for the death penalty in light of our ability to incarcerate for life?
Because we have people like William Wells, who killed 5 people under the former administration and was given life sentences, promptly went off to prison, and he's killed 2 more people since then and bragged about it. He's only killed 1 more. He tried to kill another one. Sorry. He tried to kill somebody while he was in prison. And the problem with life sentences, they never stop appealing. They will tell you right now we could save so much money if we abolished the death penalty and just gave people life. But we litigate life in prison cases just as hard and as expensively as we do death penalty cases. They never stop appealing probation sentences. I mean, don't buy into this money argument until you know all the facts behind that. But the other thing about William Wells bragging about killing, basically he said, I told you I'd do this if you didn't give me the death penalty. He wrote a letter saying that, and specifically named the 2 prosecutors that gave him life and said, this new murder is on their hands. Now, the problem is you can't stop someone with a murderer's heart and murderous intent from killing. And the only proper sentence for certain people, especially somebody who kills 5 people, and by the way, it wasn't at the same time. He killed them sequentially within about a week. So he was basically a serial killer who operated in the space of a week and killed all these people. So is it that we want to just put him away for life, or does he deserve the death penalty for what he did? And I can't think of anybody that's on death row out of this circuit right now who did not deserve the death penalty and did not get an amazingly fair trial with a lot of good representation, some of which is at this table right here. Unlimited appeals, unlimited amount of money spent on experts to defend them, unlimited mitigation. Winky Dink the Clown, one of the ones I had with Mr. Chipperfield. They can even come into a penalty phase and present a color poster that their client did and claim that as mitigation. A jury gets to hear everything before they make a recommendation and before a judge imposes death.
So let me
very careful process.
Bounce one or two things off. What about this financial thing this court has brought up? That we do hear this a lot, that death penalty litigation is much more expensive. She's questioning that. What's your guys' experience? Do you have any statistics or anything?
Well, one of the newer issues that have come up for finances that the legislature has put into effect is that they've created a second-tier public defender's office, or regional counsel's office. I guess they thought it was too expensive for the death penalty cases to go out to the private bar. So now, the death penalty cases, if they're conflicted out of the public defender's office, they go to the regional conflict counsel's office. Unfortunately, the regional conflict counsel's office is very, very busy taking the conflict cases from the public defender's office, and you give them a death penalty case along with their other cases. you have to wonder how much time they're going to be able to devote to it. We don't know that yet because our regional counsel's office just got the death penalty cases about 2 years ago. They had one person that was lead counsel qualified to take these cases in. That person left to go to the federal public defender's office. So they're just kind of sitting there with 5 or 6 cases. That was our legislature's way of saving money. I don't know.
If I could piggyback off what Mr. Hernandez said as far as how much it costs to have private attorneys take death penalty cases, we are obviously scrutinized very intensely because it is, especially if the person is sentenced to death, I mean, that is the highest punishment you can possibly have handed down. And so those cases have priority in the appellate courts. And what they're doing is a lot of them, in my experience, I see more death penalty cases coming back because of the penalty phase and not the guilt phase. It's because the attorneys didn't put on enough experts. They didn't dig deep enough into the defendant's background. And so what we're having to do is move the court during the pendency of the case, when it's at the trial level, for expert after expert after expert, trauma experts and neuropsychologists and regular psychologists and who are some of the other mitigations coordinators are now almost required on these cases. And so we go to the courts because we need to and we have to. If this case comes back on a 3851, we have to be able to say, these are all the things that we did. And even if we weren't allowed the money for the expert, then at that point it's on the court. But we have to move the court for thousands of dollars in expert fees for the penalty phases and death penalty cases.
So are these expenses that are going to far exceed if the person is up for life in prison instead of death?
Well, yeah, because if the person is up for life in prison, you're not going to have a penalty phase. If that's the penalty, the automatic penalty upon conviction for first-degree murder, then more than half of the work of a death case is gone for the defense attorney. It is very, very complicated and expensive to investigate a person's entire life to put on mitigating facts against the death penalty. That's what causes a tremendous amount of the expense. And if the automatic penalty for first-degree murder was life, you don't have that expense anymore.
What about the retribution? That was the last part of Ms. Corey's comments. The idea that society just has an interest in retribution against the criminal for the heinousness of the crime and this type of thing. Why isn't that a valid reason to put people to death? Or is it?
What's wrong with life without parole with retribution? I think that's the answer to that. It's, do you need to go as far as the death penalty in order to satisfy the need for vengeance?
I would agree. I mean, in Florida, life without parole is a death sentence. It's just, you're going to die. You're coming out in a box either way, whether they inject something in your arm or you're living the rest of your life in prison. Because in Florida, it's without the possibility of parole.
And there's another issue with the death penalty. I mean, when you carry out that punishment, it's the end. And if you carry it out faster, as a lot of people would like to do, then you're going to execute innocent people. And I think that the Innocence Project that has been, especially with the advent of DNA, that has been turning people out of prison because they were actually innocent, has proven to us that the years of appeals and the procedures that we follow and the training of the lawyers sometimes just fail. There have been 150 plus exonerations from death row. And depending on how you define the word exoneration, at least 115 of those, according to Justice Breyer in the Supreme Court, were actual innocents. And DNA proved that. And the arrest of another person in many cases. And some of those exonerations haven't happened until the guy's been on death row for 20, 25, 30 years.
And we do want to talk about that, but I think also there might have been, before we move on to that topic, was there something you guys wanted to say on the retribution issue?
Well, I do. Then tell me what the excuse is for Presley Alston, our case, Mr. Chipperfield, still sitting on death row. Not only did he confess, not only did we find the murder weapon and link it to him, he took us to the body. We were all out in the woods and he took us right to this young man's body. He killed a young black man named James Coon, who was a college student, president of the student body at UNF, just wanted to live his life. and Presley just wanted what he had. Already a 3 or 4 time convicted felon. He took us to the body. His guilt was overwhelming. Not only did he confess, he waited till Mr. Chipperfield, I think, went out of town or something, kept calling the detectives over to confess more. It was an overwhelming case of guilt and aggravation. What year did we throw that case?
Presley Austin is crazy as a spray road. And that's why he shouldn't be executed, because we are a civilized society. He thinks he's having an affair with Angela Ford. You've read his letter.
He is not legally crazy. He did say some things that gave me pause. However, in a civilized society, we don't murder innocent young people, babies, helpless women. We don't rape, rob, and steal in a civilized society. But yet you want to say once people engage in that uncivilized behavior, let's just hug them all and let them go.
Well, I think what he was asking though is why isn't life in prison good enough? Like, why isn't that enough vengeance on this guy?
First of all, it's not vengeance, it's punishment, which is completely different. And second of all, they're not being punished in prison. They have computers. They get all the medical care they need. They get everything, they get to read. Most of them, if they don't want to work, they don't have to work. How is that a tough life in prison? And we are hoping that if the death penalty is on the table, people might be deterred from committing that crime. Maybe, just maybe, if they know that in our civilized society, we're going to hold people accountable for their vicious, heinous crimes, maybe they'll think next time before they pull that trigger.
So is there a deterrence factor here? Do you guys dispute that the death penalty actually does deter crime in some way?
Well, you're
You're the defense bar.
the odds that your case will be overturned are greater than the odds that the sentence of death will ever be carried out. So how is that a deterrent? There are 400 people on Florida's death row, and I've got some there from the early 80s. So that suggests to me it's not a deterrent. Now, there are studies that come down on both sides of this question, and there will be studies forever that will come on down on both sides, and it depends on how the studies are done and who's doing them. But just from experience, and I think that the people on my side will say this, a lot of the people who kill somebody don't think they're going to get caught, and they don't think about consequences. A lot of the people that we represent, when they make a decision, instead of looking through a window and seeing the consequences, if I do this, then this, then this, and they can see because it's glass. My clients are standing in front of a wall, and they do something, and then the wall moves back 3 feet, and they say, I didn't think about that. Because they didn't think about that. Their brains, many of our clients, not all of them, their brains don't work the way yours do, and they don't foresee consequences. So the off chance that they might someday get a death penalty for what they're about to do, to get that money or to get those drugs, it's not in their head. I think that's a fiction.
Ms. Bonnie, you want to add something?
Yes, sir. And also, a lot of the people that we represent are from neighborhoods where they're more likely to be killed on the street than after being convicted and sentenced to the death penalty. It's just not a deterrent. Death is not something that scares them. They live in it. They live amongst it.
What about Mr. Guy? What do you think? In your experience, do you see that the death penalty has deterred crime in some way?
Well, there's no way to know for sure because we don't know if somebody's stopped doing what they were going to do because of the death penalty. I tend to agree with Mr. Chipperfield that these folks who are about to commit these types of crimes are not going through the mental analysis of what might happen to me if this goes the way I intended to and I get caught. So I don't think deterrence is a big factor in the death penalty. I really don't.
All right, well, let's go back to Mr. Chipperfield's point earlier then about exonerations. Does the fact that we have people being exonerated from death row, isn't that in and of itself a good argument to not have a death penalty? Because you can always correct it if they're in jail for life, but it's a little late if they've already been executed.
All right, I just want to correct one thing. None of those exonerations are out of the 4th Judicial Circuit. in the 4 decades we've been seeking the death penalty, none of them are exonerations. And again, he did qualify and say it depends on how you define exoneration. One woman that Bernie Del Riondo went and debated the death penalty with recently at Tiger Bay Club put up 2 cases. One of them, she said, was an exoneration. It was a life case. It was Chad Hines. He wasn't exonerated. The judge granted him a new trial based on further analysis of DNA evidence. But that got touted as an exoneration. To this day, we could recharge that case at any point, and probably will once we get to the point where we need to with the DNA technology. A second one she put up there, she said, well, Duval hasn't had any exonerations from death row, but we likely executed an innocent person. I said, they're going, who's she talking about? She put up a picture of Leo Alexander Jones, a case that I personally handled the post-conviction matters on. I was in the courtroom when his co-defendant Glenn Schofield pointed at Leo Jones and said, not only did none of these other people the defense is claiming did it, I know you did it, Leo, you know you did it, and your lawyer knows you did it. That was the testimony under oath of the man who was with him when he sniper shot a police officer. Now that's what's going on in these cases. We're living them minute by minute, witness by witness in the courtroom, but people are running around talking in sound bites, not even knowing all the facts. So I can assure you there was plenty of evidence to sustain the death penalty on a man that anti-death penalty people are claiming likely was innocent, because we were there. We know the facts.
If we pulled it back maybe from the Fourth Circuit and maybe took a step back nationally perhaps, and if we conceded that some percentage of those exonerations might have been an actual innocent situation, maybe there was one out there somewhere, is that one enough? I mean, to say we shouldn't have the death penalty because we might execute an innocent person?
I think what we have to do is what we've been doing, what I've done for 34 years. You teach that the better you make a case from the ground up, the better a product you'll have so that it can withstand the kind of appeals that Mr. Chipperfield mentioned. We teach law enforcement. I've been teaching constitutional law for 34 years. Don't put your hands on a suspect unless you have reasonable suspicion or probable cause. Do this. Take the extra mile. Pull the phone records. Test all the physical evidence. Do it all. Get an overwhelming amount of evidence. Audio tape people surreptitiously. Use everything in your arsenal of law enforcement tools to make sure you have a case that's overwhelming. And don't ever rely on one witness ID, because a lot of those exonerations were based on they were either rapes or murders where there was eyewitness identification that was faulty. And so what we do is we try to prove it beyond any doubt when we can. And so I think the way to do it is to make sure we don't rush to judgment. I don't mind that phrase because it's something we teach. Don't rush to judgment. Don't arrest unless you absolutely have to. And build that case. Build it through evidence, build it through testimony, build it beyond any reasonable doubt, trap the defendants in their own lies, and when you build that kind of a strong case, you can withstand the types of things that you're suggesting.
You know, I would say this, that not all prosecutors are as diligent and as careful as Ms. Corey, and I'll admit that. I think that's really true. But the problem is there's a margin of error. And the question is, what's the acceptable margin of error when you're dealing with human life? That's the question. You know, is it going to be, 1 out of 10, 1 out of 100, 1 out of 1,000? And I think the way you have to think about it is, what would be the acceptable margin of error if it were my brother, my mother, my father? I think you have to personalize it, but people don't do that. People say, well, it's close enough, and that guy doesn't deserve much fairness anyway, because look what he did. So you're bootstrapping your argument. You're assuming the guilt, and he's a bad person, so he doesn't deserve the fairness that my brother, my mother would deserve if he were the one who's charged. I think you have to think about that, because there will be errors. It's just a question of what you will accept as your margin of error.
Mr. Hernandez, let me ask you a question kind of with the military thought. We know in war there's also going to be collateral damage, and there's going to be innocent people who die when we drop a bomb on, Al-Qaeda or something. And yet that we still might just be justified in dropping that bomb. Why isn't the death penalty something like that? That, yeah, there may be some, at the margin, some collateral damage, a few innocent people get executed, but all in all, it's still better for society this way.
I probably, and you kind of put it into military terms, and when you're in the military, you have discretion, and it's discretion all the way down from the command. What happens in 1983 when you have a first lieutenant leading the patrol in Beirut, and he's fired upon by snipers, and he's got a young woman holding a child right next to the sniper. The law of war allows you to fire back upon the sniper, take out the mother. Or does the young lieutenant take his people into the building and pursue the sniper without the child and the mother being present? In my mind, and I've always thought this, one life is too much in war or in the death penalty if a person's innocent. A tough standard that a Marine officer that has been in combat can hold himself to, but one life's too many. I don't know whether I answered your question, Professor.
No, I think it was an impossible question. I think you did a pretty good job with it.
That was a good question.
So let me ask the audience then. We've got some time left here on the panel. Some of you may have been concocting some great questions now, and Brandy has got a mic. Is there anybody who has a question that, go ahead and raise your hand, and Brandy will bring a mic over, and you can identify, right over here, Brandy. You can identify a specific panelist, or if you just want to ask the panel in general. Is that not working for you?
No.
Why don't you just go ahead, sir, and stand up, and you can ask your question real loud.
My name is Timothy Jones. I'm a 1L. I guess with a lot of cases from the 80s, we have these guys that are sitting on death row for, going on 30 years now. Well, yes, there is some DNA that exonerates them, but in modern times, the prosecution is getting DNA that absolutely convicts these guys. So do you guys see the future being where these guys are going to sit on death row for another 30 years, starting, around our times? Because honestly, I don't see a need for it as a citizen.
So you're asking whether we're going to have shorter death row times because DNA evidence is going to help the prosecution?
I think, obviously, the DNA has been a help. It can also be a hindrance. It's only as good as your ability to prove it shouldn't have been there. It's kind of like a fingerprint. But I think what we have to have is some finality. And we passed a rule that says now automatically all death cases go to the Supreme Court within a year, and judges are supposed to keep these cases on track. But again, we have cases like the ones I mentioned, Presley, Austin, and a few others, who don't have any more litigation. Their post-conviction is done, and they're still sitting there. And it's that part of the process that if we are, where the case is overrun, where there is no doubt, where people aren't questioning their innocence, where they led us to the body and confessed every which way. Those are the cases where we could hold off on the ones where there's still litigation claiming they're innocent. But these people, again, are getting a lot of due process. From the very second that they're arrested, they're getting a lot of due process and a lot of money put towards their defense. I'd have to read up on some of the cases they're referring to, but I know they can't name you one because, see, we staff these cases. And the defense can come in and meet with me. I meet with defendants and their lawyers and their families routinely on mitigation. Not on death cases usually, but I've met with defendants all the way from Christian Fernandez to one I went up to Nassau County to meet with him because they wanted me to waive the minimum mandatory. I meet with them personally. So we do a lot of staffings of these cases, and if we're not sure we can prove it beyond a reasonable doubt, or if the defense has evidence, they bring it to us, and we work with them sometimes to make sure we've got the right person. So I think we just have to keep pushing for a better quality product so that once the death penalty is rendered, it would be a quicker process.
You guys foresee shorter death penalty times now with DNA evidence?
Well, I think there are 400 people on death row, and if they start executing 10 a year, that would be a lot more than they've been executing the last 10, 15 years. You can do the math, unless the people that you're mentioning would move ahead of the rest.
They have to be executed in order?
No, they don't have to be. The governor can choose whoever he wants, but is that what we want in Florida? I mean, do we want to be, the leader in executing people? You know, it could be that that's visionary and that that's the movement, that we're on the front end of something that is creating a better civilization to execute more people. And that that's visionary, and that the rest of the world, all of Europe, and most of the rest of the world is just behind the times, and we're on the cutting edge in Florida. It could be, but I don't know. Is that what we really want to be in Florida?
No, I want people to stop robbing, raping, and murdering innocent people is what I want. So when you can give me guarantees about that, then we'll talk about how civilized our society is. But right now, the men and women in this room can't go to an ATM without worrying that somebody's going to put a gun to their head and take what they've worked their whole lives for.
I think there was another question. Go ahead, Ms. Spear.
Hi, I'm Amanda Spear. I'm a 1L here at Florida Coastal. My question is, we've slightly addressed the issue of cost for the death penalty trial, but why should I, as a taxpayer, pay for a guilty man to spend the rest of his life in prison, as you said, with access to computers, good food, whatnot, instead of lethal injection? In other words, on average, what is the cost-benefit analysis between a man or a woman spending her life in prison versus me paying for lethal injection, my tax money going to lethal injection? Moral issues aside, not putting a cost on life.
And I'll probably just give it in generalities. John, please correct me if I'm wrong, or Angela. Right now, a death penalty case is probably about 3 times more expensive.
Is that the litigation as well?
Pardon me?
Is that the litigation as well, sir?
Yes.
Like as,
Yes.
3 times more expensive over the life of the litigation?
Correct. We would love to bring that out in jury selection and in the penalty phase, but in Florida, that's not part of the mitigators. But whenever we have a juror that asks that question, we love to answer it as quick as possible, as long as the judge doesn't stop us. That's on this side.
Is that accurate? 3 times more expensive to litigate these cases, Mr. Gunn?
And I don't know if that's accurate, but I can tell you, as Ms. Corey said earlier, these people doing the appeals, the attorneys, they're not going to quit if we take away the death penalty. They're just going to start appealing the life case. So the appeals and the costs are going to be there no matter whether they're serving life or death. So it's not going away. That's just the cost.
and I guess that's why what my question is, how much is lethal injection and how much, on average, litigation aside, how much am I paying for a person to be fed, showered, entertained in prison? What is that cost?
People
It's like a great place. I need to check this prison thing out.
People aren't lining up to go to prison. I mean, is there anybody in this room that would like to go to prison to experience it? I think that's overstating the expense. The expense starts from the very beginning, and there are lots of elements to go into the fact that death penalty cases are more expensive. The first you start out with is judges have to be specially trained to handle death penalty cases in Florida and many other states. The defense attorneys, the prosecutors have to be specially trained. You never have just one defense attorney. You're investigating not just the facts of the crime so that you can litigate at trial what happened in a 1 hour or 10-minute period. You're litigating the entire life of the client, which takes huge amounts of time to prepare. When you go to trial, you're death qualifying a jury, which takes at least 3 times as long as picking a regular jury. So you're occupying the court time. And it's not just one trial. You have the trial on guilt or innocence, and then you have a penalty phase trial. So, and then the appeal is to the Florida Supreme Court. As if they don't have enough to do already, they've got to handle all these death penalty appeals. And they have specialized lawyers handling the appeals. So the added expense starts from the very beginning. It's not just the appellate remedies later on. And then you have the housing. Death row housing is very expensive because they're one-man cells and they have extra guards. You can't put a death row inmate with another death row inmate. So the expense keeps building throughout the case. That's why it's so much more expensive. And the appeals add to it also, but those appeals are necessary, as we know, because if you don't do it, then we're going to execute more innocent people.
All right, I think we have time for at least one question, maybe 2. We'll take here and then there. Go ahead.
I'm going to be like on the same track what you've been talking about, Tyler and the 1L. The whole price argument, I don't want to say guilty, but I guess I could. You guys feel a little guilty that you guys are the reason that it keeps like appealing and appealing, and that's the main driving cost of the cost. And so instead of those millions of dollars, I don't want to put a price on a life, of defending a life, but those millions of dollars that are being eaten up by these appeals that are so, like on cases that she said, so blatantly obvious of confession.
Like, who makes the decision that it's blatantly obvious?
So this is maybe the standard defense. How do you guys look yourselves in the mirror defending criminals?
Instead of defending these like obvious cases, which I'm sure, like she said, there are some. Like those millions of dollars could go to other things that defend innocent lives, like police officers.
Okay, well, let's talk blatantly obvious. The one that comes to my mind is the Boston Marathon bomber. Blatantly, obviously guilty?
I didn't say that.
Yeah, I would. Yeah, he was guilty. There's no question. Even his defense lawyers didn't raise that. But because it's a capital case, you had a penalty phase that went on for what, 2 weeks, 3 weeks? Because his entire life was relevant to the decision about life or death. So that wasn't blatantly obvious. That jury took 15 hours to deliberate whether he should get life or death.
And like I said earlier, most of the cases that come back on appeal that are death penalty cases are because of the penalty phase. It's not because of the guilt phase. It's because the lawyers have been ineffective in some way. They didn't dig deep enough. They didn't hire enough experts, which is why we have to keep going to the courts and moving the courts for all of this money so that these cases don't keep coming back on ineffective counsel.
Well, yeah,
And
I was talking about the cases that you know are clear cut. Like as she said, confession.
But penalty is never clear cut. Guilt might be if there's a confession, a co-defendant, an eyewitness. But those cases, if there was no death penalty attached to it, would just be mandatory life without the possibility of parole. But when you go into a second phase, which is the penalty phase, that's where all of these appellate issues are rolling down from.
So you don't feel responsibility.
Not one I know.
But let me ask this, is it your decision to appeal or your client's decision to appeal?
Well, there's an automatic appeal from the death sentence at the first level. But no, there's a code of professional responsibility that tells a lawyer when to stop filing motions, and that is when they become frivolous. But frivolous, the way it's defined is if I can argue for a change in the law can be 100% against me, but as a lawyer, I can argue for a change in the law. So I don't think that's frivolous.
So have you ever appealed with a client that you know is guilty?
Well,
Probably every appeal, right?
You ever not appealed?
All right, let's do this. So I want to get this last question because then we're going to run out of time. Go ahead, Lisa.
Hello, Lisa Patua. My question kind of goes to what Ms. Corey said of a person deserving the death penalty. Now, would you think that's more subjective than objective, using it to a legal standard? Is there a legal standard for deserving?
There is. The legal standard is what crimes qualify, whether the aggravators outweigh the mitigators, and that a thorough analysis is done of that. There's a laundry list of the type of murders that qualify. We try murders all the time where we never even seek the death penalty. Michael Dunn was one of them. We had a citizen a few weeks ago that argued with my sister-in-law and said, well, I'm not supporting Angela Cree because she wasted taxpayer money seeking the death penalty on Michael Dunn. The only problem is we never sought the death penalty on Michael Dunn. We never did. We from the very beginning said this is a first-degree murder case, we're not seeking the death penalty. So I don't know where the confusion comes in. We try cases all the time where it's a first-degree murder, but we don't seek the death penalty because we don't believe the aggravation outweighs the mitigation. So it is not as subjective as one may think.
And maybe if I'm interpreting the question also, it sounds like there is a lot of discretion and maybe what you might call subjectivity that has to go into that decision whether to prosecute it as a death case or
But
not.
we do it as a team approach. I make the final decision. But one quick thing back to your point about do lawyers appeal whether they should or not. We had a man out of Duval County that was prosecuted, convicted, wanted to die, wanted to be executed, and defense attorneys still filed motions trying to stay his execution and fight it, even though he wrote the governor and said, I deserve this punishment, I want to die. His name was Hamlin. And there were still lawyers filing motions, fighting it, not because he wanted it, but because they wanted to fight it.
So maybe the last word on that, is that an accurate rendition of what sometimes you have to do as a death penalty defense attorney? File motions even though your client wants to die?
Well, for instance, and I've had a client who came close to not even wanting a penalty phase, because I guess to the young lady's point, I'm sorry, I don't remember her name,
It's fair.
likening life in prison to like the Royal Caribbean or something. A lot of my clients would prefer death row to general population. They're like, I don't want to be in general population, I want to be on the row. Well, as a death penalty attorney, I still have to, even if they don't want a penalty phase, maybe proffer it to the judge, like what we would have presented. Because we are defending this person based on the law and based on, I mean, just fighting for his life, no matter what he personally wants. Now, he can choose no jury in the penalty phase, but we still have to proffer all of that to the judge. I mean, there's still a course of action that we need to take ethically because of our duties as an attorney.
Well, yeah, otherwise you'd be allowing state-assisted suicide. I mean, we don't give defendants what they want. If we did that, then the prison would be empty. Just because he wants death. And there again, a lot of the people who do that have mental health problems. And Mr. Hamlin happened to be a very intelligent man, but he was depressed, suicidal, and had decided he wanted to die.
So let me do this. Shannon Price and Brandy Longico, two officers from the Criminal Law Society, wanted to come up and make a presentation to our panelists. While they're heading up, I think, can we thank our panelists for their time today?